Want to say
All
anything?
right, welcome everybody, and to our second of the year Zoom conference. And our host this time around is Phil Starr, has put this together, and I deeply appreciate his work on this. I just want to take two notes. One is Francis Perkins, who was the founder of Social Security, in case anybody knew that. The other thing, and probably more important for us, is Francis Perkins founded the Civilian Conservation Corps. She's the first woman cabinet member of Franklin D. Roosevelt. And if you go to Washington, you will see her name on the Department of Labor. And the Civilian Conservation Corps eventually became the Peace Corps, and then it became VISTA. And for anybody who's out there, and there's two things I ask of you, is if you happen to know a young person or an older person who is interested in being a VISTA with us, we are looking for a VISTA starting June 6th or 7th. I forget exactly when it is. They've upped the quote unquote living allowance, which is barely sustainable. And so if people have somebody there, that would be great. The second thing I want to give a shout out to are the people who serve on our conference planning committee. And Phil is obviously one of those members, Sally Martin, and a number of other people. And also all those people who are sponsors who you'll find at our website. Deeply appreciate their time and energy and effort in this. And I'm going to be doing the next one, which is on small dollar loans for repairs for homes. So without further ado, we are going to get started here. And the final thing I wanted to mention is if there's anybody, a group, an organization, or an individual who would be interested in being a sponsor of these forums, it would be greatly appreciated. We run on thin air most of the time. And so if you're interested, contact us. We have somebody who makes a $50 contribution, somebody makes a 20, and then there's the thousands. So whatever you can do, that would be greatly appreciated. So I'll turn it over to Phil, and he will find all the solutions to housing and tenants. And never in my life have I seen so much money coming into the city of Cleveland, $490 million. It's a lot of money. So Phil, it's all to you.
Okay, thank you, Chip. Just in terms of the forum today, our major focus is on emerging efforts around providing additional tenant protections. And so we're going to have a discussion of pay to stay initiative, and then after that there'll be a discussion about the efforts to enact the pay to stay. After that, we will take questions, and anytime during the presentation, feel free to add your question to the chat. At the end of those two presentations, we'll open it up to questions about pay to stay. After that, we're going to go through a series of short updates on various activities around tenant protections, and as Chip mentioned, the funds that are going to be available to assist tenants through rental assistance. And then at the end of those updates, and during those updates, feel free to add your questions to the chat. I will be receiving those, and then we will ask in the panelists as many of those questions as possible. When we originally planned this forum, we had a couple of dates in mind, and it ended up that this was the date that worked better for many of the panelists. And although John Ryan from Senator Brown's office said this should be a national holiday, and he was surprised that we'd have a panel today, but it got me thinking a little bit about what is the connection, St. Patrick's Day, and tenants, and this whole forum. And interestingly, I was thinking about the fact that obviously Irish immigrants have made significant contributions to cultural, economic, and the politics of this country. But the first major group of Irish immigrants who came to the Cleveland area came to dig the Ohio Canal. And they ended up living in the area just west of, on the flats of the Cuyahoga River, which eventually be called Irish Town. And back then, there were a lot of single family wooden homes that were subdivided. And eventually that area became tenements. and additionally, SROs were built, single room occupancy housing, and in most cases, the housing was not well maintained. And eventually, those tenements led to, first in New York and then other places, the enactment of tenement laws, which were the foundation for what became the housing code and building codes. And it was the first efforts of cities, municipalities to get involved in saying, okay, there's an obligation among property owners to at least provide safe, decent housing if they're going to be renting it out. And for many years, the only protections that tenants had were these codes and that had been enacted. But it proved over time that as property owners did not really abide by these codes, that you needed to have additional protections for tenants. And a movement came about to pass tenant protections through the landlord-tenant law. And in 1974, the state of Ohio passed the Ohio landlord-tenant law, and it changed the relationship from a property relationship where the landlord basically could do whatever they wanted with their property. They could choose whoever they wanted to live there. They would choose not to rent to certain religious groups, the Irish, certain religious groups, and definitely people who are African American. But in addition, they also had the power to remove tenants in whatever way they wanted. And so through their evictions, what they would do is either lock tenants out, turn off the utilities, or put the tenants' possessions on the street. And the 1974 landlord-tenant law changed all that. And it basically said, instead of thinking about it as a property, it became a consumer relationship. And both landlords and tenants had rights and responsibilities. And one of the major reforms was that the eviction process now required that the landlord had to go through court and could no longer use what has been called self-help evictions. We know that self-help evictions still occur. They've increased during the pandemic, but they are illegal, and tenants do have, if they know about it and are informed, access to legal representation if a landlord does try to turn off the utilities or lock the door or put the tenant's possessions out on the street. And so in this consumer relationship, the landlord had the responsibility as to provide a decent place to live, and the tenant had the obligation to pay their rent and maintain the premises. So but since 1974, it's been clear that while the law is a good basis, local municipalities have seen that there are other needs and have had to enact other legislation in order to protect tenants. In the city of Cleveland, there's a requirement that a landlord has to provide a rent receipt, receipt for security deposit. We have special requirements in terms of security in senior buildings. We have protections for tenants in terms of water shutoffs. So municipalities have gotten involved, in addition to the state law, in providing protections for tenants. And so today, what we really want to talk about are some of the other ideas that are out there and are being proposed to further some of the protections, because one of the concerns that particularly exist is that if a tenant has rent money, if they get it through a government agency to help them, stay in and deal with the COVID situation, that the landlord under Ohio law does not necessarily have to take that money. Unlike in other consumer transactions, it would seem that if somebody is tendering their money, they should be able to get it. So we're going to start off with a discussion of pay-to-stay legislation, pay-to-stay and what it is. And Molly Martin, who is new Director of Strategic Initiatives of the Northeast Ohio Coalition for the Homeless, known to many people as NEOC, is going to give us the background of why pay-to-stay, what it does, and why it's important. And then we're going to hear from both Molly and Deborah Levy and Rem Soubey, who are both attorneys for advocates for basic legal equity, about the efforts that have been made to enact pay to stay both in our area and around the state. So Molly, I'll turn it over to you.
Thanks so much, Phil, for the introduction. Hi, everyone. It's so great to be on this meeting. I think this is the largest Zoom meeting I've been on since COVID, so I think that's a success. And I'm really excited to share about pay to stay and the momentum that's been generated in the community. Before I get started, I just want to say that this is the research and my own learning and the work that's been done on pay to stay here locally has been really, the groundwork for that has been laid by, advocates for basic legal equity, Reem and Deb, who are on this call, and then also my own participation in the Fair Housing Group and the County Housing Stakeholders Group. I've only been back in Cleveland for a couple of years, and all of the individuals in these spaces, different tenant organizers, and then especially people directly impacted by homelessness and by eviction have really just inspired energy to get involved in some of the work around tenant protections. I'm going to be sharing my screen, and when I press present, the Zoom will go away. So Phil, if you could give me like verbal confirmation that you can see the slides, please let me know, okay?
They're up.
They're up. Now they're up.
Okay, great. So I thought to get started, for those of you who aren't familiar with NEOC, we exist to eliminate the root causes of homelessness while loving our diverse community through organizing, advocacy, education, and street outreach. And I just want to say that, NEOC direct service by providing street outreach services to people experiencing unsheltered homelessness, but oftentimes we're the first place besides 211 that people in a housing crisis will call. So I really think that helps inform NEOC's strategy of having an ear to the ground to hear in the community what's happening and to hear from people who are the most impacted, for that to drive some of our advocacy work. Which is focused on organizing people to push service providers and the government to treat people experiencing homelessness with dignity as we work to change systems that cause homelessness in our community. So before I get into the details of pay to stay, I really want to take a step back just to talk about the idea of housing justice being a racial justice issue. So as many of you know, last year, Cuyahoga County and the city of Cleveland declared racism as a public health crisis. In our work at NEOC, we really see the root causes of homelessness at play every day when we look at the legacy of racism, structural discrimination, and how a lot of Black Americans have been excluded from employment and housing in different institutions, that shows up day to day in the work that we do, and especially in housing, and that Black people in our community really do experience the highest rates of poverty, unemployment, and health disparities, and that all of those things, especially incarceration, and that just leads into housing. And I think, just the lack of safe and affordable housing in our community is a huge cause too. A single parent would need to work 74 hours a week just to afford a 2-bedroom apartment anywhere in Ohio. I thought it would be helpful to share just a couple of graphics, because something that we're trying to pivot now is that as the vaccine is rolling out and we're seeing lower infection numbers, we're having to grapple with some of the longer term economic impacts of COVID. And I think just looking at the fact that people of color do face higher unemployment rates, that will show up long term, even beyond the high infection rates, that we do kind of live in a different world. And I thought even the second graph was a really interesting thing, that, beyond COVID, we do live in a different world when you look at how meetings are taking place and the way the nature of work is shifting, that a lot of these issues, health, social, and otherwise, are going to continue to have a disproportionate impact on Black and Indigenous people of color. And to get specifically into evictions in Cleveland, something to kind of frame the case, there are about 9,000 evictions filed every year in Cleveland. And among those evictions, 8% of them are filed for non-payment of rent. And something that I find pretty surprising is that the average back rent owed is about $1,200. And demographically, among evictions in Cleveland, 77% of those tenants are Black. 76% of them are women. Many of them have children in the household with an average median income of just $1,200. And according to legal aid, about 30% of tenants do have a previous eviction filing. I do want to note that in 2020, there was a decrease in filings based on local and federal eviction moratoria, but it was reported that there were still 4,015 eviction filings last year in the city of Cleveland, which is a drastic decrease based on the average of 9,000. But there were still filings that were made, and even despite the moratorium, people are required to attend their hearing and to present the declaration form to show that COVID has had an economic impact on them for them to remain in their house, even if they haven't paid rent. So to pay to stay, for those of you who don't know, Ohio is just one of 5 states that permits a landlord to file for eviction immediately upon non-payment of rent. I think something that is important to note is that rental assistance is, by far the most impactful thing that will help tenants. It makes landlords whole. But I think it's important to note that emergency assistance that's available doesn't necessarily offer full protection. We have gotten some calls at NEOC. There are some cases where landlords do refuse to accept rental assistance. I think that was much more common before, and we've seen, and I know CHN has seen a drastic increase in a landlord's willingness to accept rental assistance. But there are a lot of people in Cleveland who live in units and there are some forms of financial assistance where people don't qualify for it. There was a really impactful story that came out of Slavic Village where their local CDC had, 200 plus residents who didn't qualify for the aid because their unit most likely wouldn't pass inspection. So I think, even beyond the COVID rental assistance and given that so much of the burden of administering that assistance is really put on just a couple of organizations in our community who are doing amazing work and working very hard, there are still some constraints for that large flow of money to come in that we kind of see pay to stay as something that does add a buffer in the time period beyond the moratorium and moving forward, that's based in fairness and can kind of allow for more mediation to occur outside of court if people are behind on their rent. And I thought it would be helpful to provide this graphic that kind of talks about how the eviction process works for Ohio's law currently. So if a tenant is late on rent, a landlord can serve a notice to pay or quit. This is known as the 3-day notice on the second day. That I've heard from who have called with questions about the 3-day notice. They immediately think I have to move out. This is telling me that if I don't move out, then the landlord has the ability to file for an eviction within 3 days. And then basically how it works under Ohio law is that the tenant can tender rent after it's late, but technically the landlord could refuse that still. And in some cases we've heard from legal aid and from tenants too, is that sometimes rent can be taken by the landlord and then used as evidence for late payment to show proof of that. And so even if the tenant does show to their hearing and presents the rent, it could still technically be refused. I know based on conversations I've had with Judge Scott in courts where mediation is heavily pushed that doesn't happen. And I know that that some landlords would pick for just being late on rent. I think a lot of tenants do have the experience of the 3-day notice being the only knowledge and interface that they have with the eviction process. So a lot of people end up leaving. So under paid work of pay to stay was something that a community enacted. So once the rent is not paid on time, if the tenant pays the rent and then the reasonable late fees per day it's late prior to the filing of an eviction action, it avoids the eviction. And I would say at this point, before the point where an eviction gets to a hearing, it kind of encourages landlords to work with a tenant outside of court, kind of disincentivizes filings to some extent, because pay to stay would essentially be a codified equitable defense that already exists, and it kind of levels the playing field a little bit, knowing that the judge would essentially have something to turn to that would sort of require them to say, hey, pay to stay is an ordinance that is here, and the tenant had offered the money and late fees, it has to be accepted. Now, if it gets to the point where the hearing does occur, the one difference is that, the tenant is responsible for the full rent, they're responsible for the late fees, but then they also would be responsible for the court costs there. And if that is presented by the time of the hearing, then it would avoid the eviction for the tenant. So I know that some of you might have some questions too, which I listed here, which is, so why does pay to stay matter if many landlords say that tenants don't ultimately come up with the money, or that they don't show up to their hearing? I would say that pay to stay essentially codifies a landlord best practice. I have been having a lot of conversations and have been on a lot of public meetings where landlords have been giving feedback on pay to stay or talking about the effectiveness of an ordinance like this. And I hear a lot, especially there's this distinction between mom and pop landlords and then more real estate investors who are operating housing. And we see that a lot of mom and pop landlords would work with a tenant and that they would mediate with them. And that often in situations where someone does end up going to a hearing and there's a hired lawyer by an LLC in an apartment, that times where we see the most like strict unbending outcome for a tenant, where even if rent is tendered, it is refused. And also, I kind of changed the statement, what you don't know can't hurt you, to what you don't know can't help you. I would say as an advocacy organization, things like pay to stay kind of create an opportunity for us to provide know your rights workshops, to have something tangible for the community to give the courts and to give to renters that they know exists. Because there is this deeper issue that 9 of 10 tenants don't show up to their hearing, that most of their experience with the eviction process is the 3-day notice. When I gets a 3-day notice or they're about to be evicted and they call NEOC, like, it's a very intimidating, shameful, scary process to go through, and most people just leave. And I think kind of leveling the playing field and letting renters know in a community that they do have a right, I think it would encourage more communication between tenants and landlords outside of court, and then if it ultimately ends up going to a hearing. And then also, I get the question a lot when we present pay to stay, doesn't this already exist? It kind of seems like something that's a no-brainer, because obviously the eviction process and the re-rent process for a landlord is an expensive thing. And there are, in private leases, oftentimes there does exist a grace period that tenants have, but under Ohio law, for those who are on month-to-month leases or those who don't have a grace period in their lease, that's just a little distinction there. And I also do just want to note too that beyond infections, we do think that COVID will have this long-lasting impact. So providing something like pay to stay will just give us an opportunity to be able to educate tenants and to account for the fact that, and we'll be hearing an update about this later in this forum, but there is a tremendous amount of rental assistance money coming into our community that should ensure housing stability for renters. And the processing of those applications and access to that money takes quite a bit of time to process. And the onus of submitting those applications is on the renter, and it does take a long time. And I think something like pay to stay in that period and in the long term can help ensure that in the mediation process and outside of court, that landlords are working with tenants, just knowing that emergency rental assistance can sometimes be slow to get there. So where does pay to stay exist in Ohio? New news that we have is on Monday night, Lakewood City Council passed pay to stay, and in the village of Yellow Spring, Toledo, an ordinance in June of last year. Deb, who is on this call, will talk a little bit about the context of the timing of that and an update on that. And then Reem Soubey from ABLE was instrumental in assisting council in Toledo and passing pay to stay there, and also with source of income, and she'll be providing an update on that. But beyond Lakewood here locally, a pay-to-stay ordinance has been introduced in the city of South Euclid and is still in committee there. And there are drafts that, and pay-to-stay is under consideration in the city of Cleveland, then Cleveland Heights. And a couple of weeks ago, I had the opportunity with some members of City Council and City County to talk to Judge Scott just about how the court has been working during the pandemic, given that all of the hearings are happening virtually and that they're really encouraging mediation, given that there's some confusion around just the moratorium and the declaration form needing to be presented at hearings, and then also just encouraging mediation when a lot of tenants who end up showing to their hearings say, I've applied for emergency rental assistance, but it's still being processed. How can we communicate that with my landlord? Because, you know, obviously that we're still waiting on that. But there is an upcoming discussion that's coming up. NEOC is going to be planning a roundtable with some members of Cleveland City Council, housing advocates. We want landlords to be at the table for that. And for those of you who are on this call, I just wanted to kind of make that known because I think it would be great to have a variety of different voices and perspectives on that roundtable. So I do have my contact information here. If any of you are interested in participating in that, we're still kind of settling a date for it. I think I would like to have it a month out just so we have time to set a date that people can have in their calendars. But at this point, I'm going to stop sharing my screen because I think it would be great to hear a little bit from Deb about pay to stay in Yellow Springs, and then we could hear from Reem too.
Well, great. Thanks, Molly. That was a really helpful discussion on pay to stay. So as Molly mentioned, my name is Deborah Levy, and I'm an attorney with Advocates for Basic Legal Equality. I work out of our Dayton office. I'm actually in the office today because I live in the country, so I can completely relate with bad connection. So hopefully you're able to hear me okay from my office in Dayton. Molly did a great job of talking about sort of the background of pay to stay. And in the spring, when the pandemic began raging, we had internal conversations about what we could do to try to keep tenants housed during the pandemic. As many of you know, Ohio was one of only a few states that failed to issue any statewide eviction moratorium. I think we were one of only 7 states nationwide. So besides the CARES Act that provided some protections for tenants in subsidized and public housing in the spring, there was really no protections for those in private housing. And as we know, in the spring, Ohioans were facing really the worst recession of our time. We know that millions of Americans were laid off from their jobs and that the unemployment rates in Ohio had surged to the highest levels ever recorded. And so we were thinking, you know, we anticipated that there were going to be thousands of tenants that couldn't pay their rent because they were not working, and we were exploring ways to address that. We reached out to the village of Yellow Springs, which is located in Greene County, about a pay-to-stay ordinance. And after many discussions and many meetings, we were successful in getting pay-to-stay passed in the village of Yellow Springs in June of 2020. The ordinance that Yellow Springs passed is time limited. It only lasts until the end of the state of emergency. It does include a late fee provision. It caps late fees at either 5% of the monthly contract rent or $25, whichever is higher. It also requires landlords to provide rent receipts, and then it has the pay to stay provisions. And this ordinance provides 3 opportunities for tenants to pay their rent. First would be prior to excuse me, let me just look at this. prior to the filing of an eviction. So they receive their notice and they offer their rent prior to the filing of eviction. The second stage would be prior to the eviction judgment. So after the filing, but prior to an entry of restitution. And then the third stage would be prior to the move out. So it could be after the eviction judgment, but prior to the time that the bailiff or the sheriff or whoever in your community would come out and forcibly remove the tenant. The options for the tenant to pay, what they have to pay changes depending on the stage. So once the tenant's at the court stage, they would have to pay a court cost. So that's sort of the second intervention. And then the last intervention, if it's prior to the move out and after the landlord has filed the writ, they would have to pay the court costs and the costs of the writ fee. So we were very pleased that this ordinance passed. It's different. Pay to stay is different from the CDC order halting evictions because the CDC order, while it could suspend an eviction, it doesn't require a landlord to accept rental assistance or accept rent from the landlord. It just suspends the eviction hearing, or in some courts, suspends the move out during the term of the order. And I'm going to turn it over to Reem, who's going to talk about the Toledo ordinance.
Thanks, Deb. So, hey everyone, I'm Reem Sobey. I'm an attorney with ABLE. ABLE is short for Advocates for Basic Legal Equality. If there are legal aid attorneys on the call, you might be wondering how we could engage in lobbying. ABLE is a nonprofit, but we are not LSC funded. So we engage in some lobbying at the directive of community members and based on the needs of the community in a fashion that is not a substantial portion of our activities. So when the pandemic started, we did have internal conversations, as Deb mentioned, and we were hearing from a lot of people who are waiting on some money to pay their rent, were collecting money, but couldn't make their rent exactly at the right time that they were required to. And that was a very important concern, not only for those tenants, but also for the community at large. Because research shows that an eviction not only harms the immediate family facing the eviction, but also the community and the city. The cost of an eviction to a city is much larger than that 1 month of outstanding rent that the tenant owes and should pay. Because then the city has to deal with potential homelessness, support for the family, potential mental health ramifications for the family that now has to undergo an eviction, and the children could face a disruption to their education if they move and cannot continue to attend the school that they were attending before. So Yellow Springs took the first step and passed a pay-to-stay ordinance. We then started having conversations in the city of Toledo about the city of Toledo passing similar legislation. Each ordinance is a little different from the other cities, so you'll find that Yellow Springs one and Toledo's, South Euclid, and so many others have slight variations depending on the negotiation that took place between the advocates and the law department of that city, as well as sometimes the very specific advocacy points and needs of the community. But you know, something that we made clear and that we learned and became more clear to us during this advocacy is that an eviction is not only the cause of poverty. So not only are people in poverty going to face more evictions, but also evictions themselves throw people into poverty. And so it was very important to our city council, and it was very important to the people in the city of Toledo to ensure that actions were being taken to prevent families that were staying above, but were at risk of falling into the plight of poverty. And so the ordinance that was passed in Toledo has only 2 opportunities. So it does not include an opportunity to pay outstanding rent after a judgment. So you'll see here that the tenant can tender rent prior to the filing of an eviction action or prior to an eviction judgment. Once there's a judgment issued against the tenant for restitution of the property, the tenant does not have that opportunity in Toledo. We wanted to get the third, however, we were not successful in getting this third opportunity for tenants in Toledo. Now, the other distinction that appears in the Toledo ordinance is that it does not create a right. It creates an affirmative defense. And so a tenant who tenders payment shall have an affirmative defense to the eviction that is ongoing against them. And what's the difference? The difference is that there's still some room for the magistrate or the judge to issue a decision where they have to accept this affirmative defense. But as Molly very eloquently stated, what you don't know can't help you. And most tenants are not represented by counsel. So tenants show up to court, they don't have an attorney. What are the chances that they're going to do their own legal research and discover that they have an equity defense that they can raise because they can offer to pay outstanding rent? The chances are very low because, you know, even as an attorney, I don't casually read about laws that don't come up in my research at work. So if there's something in my personal life, I probably don't know the law that surrounds it. And the same and even more can be said of tenants who are not attorneys and who are not trained to engage in legal research. So this law codifies the affirmative defense which exists in case law in the state of Ohio for tenants to be able to say, well, I am offering to pay rent. Why is this landlord proceeding to evict me? We also have a rent receipt requirement section in our ordinance, and we have a reasonable late fee cap. And I'll scroll down to the reasonable late fee in a second. But I want to mention that, you know, when we started having those conversations and we were contacted by media, a lot of people asked, I'm not sure why this isn't already law. Why would anyone oppose accepting rent? If you're a landlord and if you don't have any other issues with your tenants, most landlords would be okay with accepting late rent. Well, there's a couple reasons why a landlord may not accept it. A, the landlord could be spiteful or could be a bad actor or could be one who doesn't want to give the tenant another chance. The tenant messed up once, they now lost faith in them and they just want them gone. But there's another situation, which is that a landlord could have another reason that is causing them to want that tenant to be removed from that property, such as a potentially racist or discriminatory reason. But they could now just use this and get the tenant out without having to attract any attention to their discriminatory reason. So this sets up a protection for tenants. It does so generally without harming tenants, without harming landlords who are bad actors, because they are not going to be shorted their money. They're still going to receive the money. And the only way that the tenant can qualify for this protection is if they make an offer of the full amount of outstanding rent. So let me look to the reasonable fee portion that we have here. So we cap our reasonable fees in Toledo in our ordinance is capped. And it says that you cannot charge a tenant more than $25 or 5% of the monthly contract of rent. Again, reasonable late fees and the cap on reasonable fees, while it doesn't exist as a per se cap in statute in Ohio, it is part of case law, which means that a tenant who's represented by counsel is going to probably raise that issue and say, well, you can't just charge me $500 per month of late rent when my rent was only $1,000, because that's not reasonable. But again, most tenants are not represented by counsel, whereas landlords have better access to attorneys because they often have multiple properties, and so it would make sense for them financially to have counsel. Tenants often are just renting one home and they don't have any dispensable income to spend on an attorney because they're trying to preserve that money for their rent. So, we're really excited. We passed our ordinance here in Toledo. The ordinance in Toledo is permanent, so it does not expire after 1 year. And we have already had at least one case that we know of where a landlord was attempting to evict a tenant, despite the tenant having made offers of late rent of money that they received from rental assistance. The landlord was declining that money, and attorneys from our sister organization, LAWO, were able to raise the pay to stay ordinance as a defense to the court, saying this tenant has the money, they want to pay the money, they want to stay in their home, they were late because of some reason outside of their control, and we want you to enforce this ordinance. So I'm gonna kick it back to Deb. I think Deb maybe can talk about other cities in progress for pay to stay.
So I just wanted to mention briefly that Dayton is also considering pay to stay, and we're still in process with that as well. I know we're probably running a little short on time, so I'll stop there because I assume we have some questions.
Okay, thank you very much, Molly, Deborah, and Reem. We have had a number of questions, but before we get to the questions, Avery Pearson, who's the legislative assistant from Senator Rob Portman's office, is on the call, but she's got a time constraint. So we're going to hear from Avery, and then after that, we'll move on to the questions. So, Catherine, if you can.
Yeah, do you need something, Phil?
Yeah, unmute Avery so she could.
Can you hear me?
Hey, there you are. Okay.
Okay. Yeah. Yeah. So I assume just an update on the Evictions Crisis Act.
Yeah.
Certainly, Senator Portman was, I would say, quite a leader in ensuring that the rental assistance provision was included in the end of year deal. As I'm sure a lot of you know, the end of year coronavirus package was kind of stalling for much of the end of last year, and it was the work of the bipartisan 908 coalition that got it back into movement. And part of the Eviction Crisis Act that we introduced last Congress is emergency grants, which are intended to be grants for tenants that have like an accident or a random financial situation that creates the eventual cycle of eviction that we see. And it's typically maybe not a full rent amount, maybe an entire rent amount of that month, but that was kind of the intention behind that grant program. And as we saw the coronavirus erupt and financial situations change, the need for some sort of gap to fill that issue as it increased for a lot of tenants became something that was timely, and certainly the senator and Senator Bennett, Senator Brown, and Young, who are all on the Evictions Crisis Act with us, saw an opportunity to pull that grant piece from the Eviction Crisis Act into the emergency rental assistance provision that was in the COVID relief bill, and just got 21 more billion in the American Rescue Plan. So with the rollout of the evictions or of the rental assistance that we see through the COVID bills that Treasury is now implementing, and aware that the implementation has not been perfect, and that is definitely something we've been tracking, and is always helpful to understand what has and hasn't gone well there for improving it. But because of the rollout of those programs, we've now been able to kind of reframe and are looking at reframing the Evictions Crisis Act reintroduction for this Congress to where the emergency rental assistance provision can be kind of carried forward in a way. And so, instead of kind of the grants that we saw in the original bill, we now have a real program to point to. So I would say overall, with the ability of the bill, the Eviction Crisis Act fully to move forward, I think we're in a really good position this Congress to get it to be signed into law, because a key provision of the bill has already been passed through our COVID relief. And, that's something we're still working through, and we're still reviewing, how to carry over a provision of a bill that was created during a time of crisis, and how maybe that gets restructured when when this is behind us to a degree. So that's definitely something that we're still, working through. But I would say that, the rest of the bill is definitely, it's stuff that we haven't been able to get past in COVID relief, but kind of improving the understanding of evictions through HUD's data, and improving HUD data on it, as well as some of the protections that were in the original bill. Those are things that are still significant, and perhaps even have more significance now because of the the economic impact of COVID-19 on both tenants and housing providers. But I guess that's kind of the crystal ball of the Evictions Crisis Act. There's a lot of talk about housing as infrastructure, and I think it'd be a really heavy lift to consider this sort of bill housing infrastructure, but definitely it's something that, we see as perhaps timely for like an appropriations bill at the end of the year, where we tend to kind of use that appropriations bill that has to get passed as a means to pass other policies. So that's kind of what we're looking at in terms of this legislation.
Thank you very much, Avery. I have not seen any specific questions for you on your presentation. So just to clarify the timeline, what you would think, you're thinking that it would be part of the appropriations bill as opposed to a separate standing bill as was originally introduced?
So no, I will definitely reintroduce it, but in terms of, I would say, the best path forward to get bills passed, often, you reintroduce it, or you introduce a bill, and that bill that you introduce is considered perhaps more of a marker, and something to point to throughout a legislative session. And I think it's something that potentially could get included, the full bill as part of a overall, omnibus appropriations bill, which can be thousands of pages, but often that's a way that folks can get policy priorities signed into laws, is to push them through the appropriations process, where you can get lots of priorities put through at the end of the year, and have a little bit more success than when they're trying to get passed as standalone measures.
Thank you very much. I know you have a time constraint that you can only be with us till 1:30. So if anybody does have a question, if they put it in the chat, I will raise that question with you. And now we'll move back to some of the questions about on pay to stay. So there were a number of questions about clarifying late fees in the chat. And one of them was the question about the recommended $25. Former Housing Court Judge Ron O'Leary informed us that already in Cleveland codified ordinances, it caps a late fee at the larger of $25 or 5% of the monthly rent, which is similar to the Toledo ordinance. But I guess anybody want to make any comments about the late fee requirement?
I make one comment. As I said, as an attorney, when I'm representing a client, I'm always going to challenge any fee that's more than that, even if there wasn't an ordinance in place. But tenants who are not represented won't know to do that. And potentially, if there were a visiting magistrate, they might not be as clear on this issue. So this is a simplification and a codification of case law for the tenants and the court.
Okay, thank you. We had a question that I'm not totally clear about, but I've recently asked for proof of approval of their unemployment claim since it was been pending since November 2020. I don't see an issue with that, but wanted feedback on this to see that it's within the rights as a landlord, since it is their income before we ask for more rental assistance for this tenant. So I think the question is, what type of documentation can a landlord ask for from a tenant in order to be able to, I assume this is to apply for rental assistance or to accept information as sort of a pay to stay.
So I think a landlord can ask for lots of information. Whether the tenant has to provide the landlord with that information, I think is another question. I guess I'm not fully understanding the question. The landlord is wanting to apply for rental assistance on behalf of the tenant. Is that the question? They're seeking documentation, because the rental assistance agency would ask for the tenant for information if they need that.
Yeah, I think.
So I see something in the chat. So I guess it's not clear to me what the purpose of requesting this information is. Is it to question whether or not the tenant is eligible for protection under the CDC order? And so they're trying to verify if they've lost a job or if there's income coming in. I think I would need more information. I'm happy to talk to this person afterwards. It might be easier. It seems very fact specific.
Okay, thank you. We had a question about what are the penalties to a landlord if they don't follow the pay to stay legislation? Is that ultimately up to each municipal judge?
So the Yellow Springs ordinance did not have a penalty in it. Basically, if a landlord would file an eviction when the tenant has met the terms of the ordinance, the court should dismiss the eviction action. What I would also suggest is that the court then seal the eviction filing, so that filing would not create a problem for the tenant later on if she was trying to seek, future housing, and a prospective landlord would see that filing. But that's not part of the ordinance.
We don't have penalties in our Toledo ordinance either.
Yeah, I think there's been, this issue has come up. I've heard it a couple of times that there's some type of concern about if there should be other type of penalties. I mean, this is basically within, would just be handled. This isn't a criminal matter. This is a civil matter, and it just would be handled by the court, where if a tenant has tendered their rent, it's a question of coming before the court as a defense or proof that they actually paid. So it's really within the jurisdiction of the court within an eviction, proceeding. And there does not need to have any other legislation or any other criminal activity. This is just similar to other things within the landlord-tenant law, which would be enforced, within the court by the tenant coming before the court if it got to that. I think, the hope would be from Molly's presentation that in many cases, once a 3-day notice was given, if the tenant tendered their rent, that you don't have an eviction filed because the rent's already been, paid and accepted. And that creates housing stability for both the tenant as the landlord, because they now have their income. Which raises a question that someone said that the word tender is concerning to them because it simply means offer. I did notice in the Toledo statute that it is specifically defined and tender. So Molly, maybe you want to talk a little bit about other ordinances that you've seen and the question of, the question about what does it mean to tender rent?
Actually, I was going to ask if maybe Deb could speak to this, because I know that there's even this question of like, a third-party rental assistance agency. How does that really work in the tender?
Sure. So the reason that we chose tender, we use that language in the Yellow Springs ordinance, is that's really, that's within the tenant's control to tender. They can't make the landlord take the rent money. So we see this all the time, throughout my career representing tenants. I've been doing this for 20 years. Tenants will offer their rent. That could be like verbally offering it or physically offering it or mailing it as an offer, and the landlord won't take it. So we felt that the tenant could do what was in her control, which is to offer the rent. And then if the landlord refused it, then there would have to be a hearing about that. Obviously, if the landlord takes it, then we're good to go.
Yeah, the suggestion was maybe to use the word remit, but I think it's really a question of how it's defined within the local statute, that the tenants actually proffered the rent in some ways. They've offered it, and it's defined in that way. Patrick Myers put in the chat that pay-to-stay legislation has also been introduced and is being considered in the city of Maple Heights. So we have one other local jurisdiction within Cuyahoga County that's considering that. We had a comment that some concern that allowing tenants to pay their rent late would allow tenants who are not the best tenants to be able to continue to stay in their property. So any response or reaction to that?
Pay to stay does not prevent a landlord from evicting a tenant if a tenant violates their lease on the basis of, for instance, criminal activity or other terms. So this is a security valve for tenants who are late on their rent but have the rent to pay. And usually that's because they had a major life incident happen or just went to the emergency room and now owe $3,000 to the hospital, and or they were facing COVID pandemic unemployment situations.
I think what I would add to that is, pay to stay doesn't create anything new. It just kind of codifies and raises up an equitable defense that already exists. So in the same way that it doesn't prevent a landlord from filing an eviction in the future, I think some of the ways that I try and logically approach this question is that, you know, a lot of people have asked, well, would we get people who are recurringly paying late because pay to stay is a right that they can use in a hearing? I would say that it doesn't make sense if, you know, the tenant is still responsible for all the late fees. And then even if they get to the point of a hearing, and a lot of renters in that situation are already low income, that it doesn't really, to me, show that there's any incentive that in the hearing itself, that it's just allowing the tenant to raise that as a defense.
Yeah, and I'll just add to the great points that Reem and Molly made. If the landlord is having problems with the tenant and there's a lease violation, they can notice the tenant for that. So, I mean, non-payment and notice for non-payment is designed in a case where a tenant is behind in rent. If there are other issues, those are the issues the tenant should be put on notice about and have the opportunity to respond to.
And then we had a question that are legal fees required to be paid by the late tenant?
So the Yellow Springs ordinance indicates that once the case is at the court stage, the tenant will have to pay court costs. Court costs do not include attorney's fees. So attorney's fees are not part of the Yellow Springs ordinance. Our view of that is that Ohio law prohibits a landlord from including in their lease that a tenant is responsible for their attorney's fees, and that sort of the order, the parts of the law that require the tenant to pay attorney's fees are only in situations where there's, you know, extreme behavior, both for the landlord and the tenant. So if a tenant would file a claim for retaliation and prevail, the court could award attorney's fees. Or if the landlord would enter the premises without notice, or a self-help eviction like you mentioned, Phil, at the beginning of this seminar. So we believe that attorney's fees are not appropriate in this ordinance.
The Toledo ordinance also provides for court costs. It doesn't mention attorney's fees, as Deb mentioned, not being allowed by Ohio law.
Okay. So we had a couple of other questions, which unfortunately we don't have time to get to at this point. If we have time at the end, we'll pick up on those. What we'll do is, if you have further questions on pay to stay, feel free to ask those. So we're now going to turn to some of our updates, and we're very happy to have Beth Cooper, who is staff on the Senate Banking and Housing Finance Committee, which I think everybody is aware that Senator Sherrod Brown is now the chair of that committee. And one of the things that he has stressed very clearly is that there's been too much of emphasis on the word banking in the committee and not enough on housing. And we've asked Beth to join us today to give us some sense of the senator's vision and what he hopes when under the idea of housing that this committee can turn to, and some of the types of, you know, tenant protections as well as other housing initiatives that would provide more affordable housing. So I'm going to turn it over to Beth.
Hi, thanks very much for having me. I'm not sure if if our great director there based in Cleveland, John Ryan, is also on the line or not. So hello to John if he's on the call.
It's a holiday, Beth. I don't know. He may not be available.
Well, I'm wearing
I
green.
see you are wearing green, as he said.
Under strict instruction from John Ryan. So I understand CSU's colors are green and white, so it has multiple benefits. It also matches my plants, which are the only backdrop I have here. So thanks very much for having me and for having this discussion. I'm sorry I couldn't join to listen in to a little bit of your earlier discussion. But I think as you said, Senator Brown is very adamant about wanting to bring housing back into the Banking, Housing, and Urban Affairs Committee's work. In fact, we had our first hearing, our first comprehensive hearing about housing needs in the country yesterday. We had a good panel of folks in just to talk about the full range of housing needs, from homelessness to homeownership, and had a really good discussion about it. In the last, kind of 6 years, most of those discussions have focused on whether or not Fannie and Freddie, the GSEs still should exist in their current form. That's really been the focus of the committee. To the extent we talked about housing, that's what the focus of the committee was on. So Senator Brown was really adamant and very excited to have that full breadth of housing needs discussed. And I think we talked about many of the things that you're talking about here today, and I've talked with some of you about in different forums. I think, he highlighted both the needs for some of the biggest issues, I think, obviously, are the over 500,000 people on any given night that are experiencing homelessness, even under the tightest definition of homelessness. The fact that we have, a quarter of all renters are paying half their income for rent, and we saw how, people being so precariously housed and trying so close to the edge in terms of their finances to pay for rent, how that set them up in COVID to be very close to being knocked off the edge of housing instability once, an emergency like COVID hits, or even just, a car breaking down in normal life. And we also talked about homeownership, how difficult it is for how on one hand you have a lot of homeowners really benefiting from the increase in equity in their homes, and on the other hand you have other folks who are, because of COVID, being knocked into forbearance or not being able to make their mortgage payments, or even just not being able to access homeownership at all because of lack of down payment or high standards that are being laid on to credit, in addition to our big structural systemic issues with housing disparities by race and ethnicity that have been with us for quite some time, and our neighborhoods. So we had a full range of those discussions, and I think that pretty well describes the scope of what Senator Brown would like to try and tackle during his time in the Housing Committee. We also talked about, specifically evictions quite a bit. Some of you may be familiar with Diane Yantel from the National Low Income Housing Coalition, who's been doing a lot of work on the need for tenant protections, and also the National Eviction Moratorium that's been put forward most recently by the Centers for Disease Control and Prevention, the CDC Moratorium. So we had a good discussion of tenant protection issues as well. I think just stepping back for a moment, even though Senator Brown has been, the incoming chairman since the Democrats won the majority in the Senate, really this first couple of months have been taken up primarily by a lot of furious work on the American Rescue Plan Act, which provided a lot of new resources for both renters and homeowners and people experiencing homelessness to arrest some of the most extreme housing needs here during and coming out of the COVID health and economic emergency that we have. That bill provided an additional little over $21 billion for emergency rental assistance, which will add to $25 billion first provided back in a bipartisan package we negotiated in December. So there'll be a total of $46 billion across the country, and over $1 billion coming into Ohio in the form of emergency rental assistance. The new package also includes $10 billion across the country. The formula is still being figured out, so I don't know exactly how much will go to Ohio quite yet, but $10 billion across the country to help homeowners who have run into trouble. And both the rental and homeowner assistance can pay for rentals, but also, or pay for that, rent and mortgage payments, but also utilities, because we know a lot of folks have run into trouble with utilities. The new bill provides also $5 billion in new emergency housing vouchers for the folks who are most likely to need the longer term assistance coming out of the current emergency. Those are folks experiencing homelessness or at risk of homelessness, domestic violence and trafficking survivors. And that's on the emergency rental vouchers. We also have $5 billion in new assistance for people experiencing homelessness. And an exciting piece of that is it's being provided in a way that will help housing development, targeting folks who are experiencing homelessness or at risk of homelessness, including the purchase of commercial properties like motels and hotels for non-congregate shelter, which we've seen be so important for immediate health reasons during the COVID emergency, but also just for providing additional housing with a little more privacy and dignity for people who are in extreme needs and experiencing homelessness. And that housing, those funds can be used for non-congregate shelter now, which could be maintained in the community as non-congregate shelter, but also could be converted later on to permanent supportive housing or other forms of affordable housing, targeting folks most in need. There are some new housing counseling dollars that will come as a result, because we know even if we provide rights and resources for folks, for both renters and homeowners, if they don't know about those rights and resources, we're not helping them. So we've provided new housing counseling dollars. There's also some additional assistance for USDA's Rural Housing Service, home ownership and rental assistance programs in smaller pots. And yet significant to help folks that participate in both of those programs. I think that's the end, also providing additional resources to fair housing organizations across the country that participate in the Fair Housing Initiatives program. There's an additional $20 million that will be coming out from HUD to augment those resources and communities as well. So that's a pretty broad array. And we're hopeful that it can be deployed quickly and well, and we'll be working on that with the agencies that are implementing it. But that's really emergency response. And as Senator Brown said yesterday at the hearing, we also want to tackle the underlying housing crises that were there before COVID hit. And COVID, illuminated those, accelerated those, but we do need to work on our long-term housing agenda for that. A big piece that we anticipate coming up is an infrastructure package, a recovery package that there's a lot of discussion about in Washington now. And Senator Brown firmly believes that housing and communities have to be part of that infrastructure push, because housing is so fundamental to people's well-being and their ability to access opportunity. So that will be a big part of the discussion from Senator Brown's point of view. So I've kind of laid a lot, and that's sort of I think people are talking about that in the near term. So I've kind of dumped a lot out there. I don't know if it would be helpful if there are any particular questions that you have about his agenda, things we're working on.
So one question or concern that exists is that the CDC moratorium ends at the end of March. And while there's a significant amount of funds that are going to be available to assist tenants, there's just sort of maybe this disconnect as to when the money hits the street as to when you're going to be able to help the tenants. I know that had to be taken out of the COVID relief bill because it didn't fall within the reconciliation requirements. But yeah. Any thought about an extension or what's happening around this whole issue of trying to protect tenants from eviction while they're awaiting funding?
Sure. Well, I anticipate with the ongoing you know, CDC's got to work its way through and the administration have to work their way through the process. This is with the administration now, but for all the reasons you just mentioned and the ongoing health crisis, and the president's been pretty clear that we can't let up now on our public health responses and protection now and expect the virus to just go away, even while we're ramping up vaccinations. I am pretty confident that they will extend the moratorium. We'll see, but I just think the circumstances aren't there that such that the public health emergency has gone away.
So are there any questions? People can type them into the chat. We'd be happy to pass those questions along. So while we're waiting, I'll ask one more, and that's about Universal Section 8, which has been, I know from the standpoint of the National Income Housing Coalition, which you mentioned earlier, is certainly one of their top priorities for as a way to make sure that any, you know, on the affordability question that you mentioned is one way to address that. So is that something that would come before the Senate Banking and Housing Committee? And what's your sense of you know, the possibility of finally seeing something that we don't have a lottery, but anybody, just like for other federal programs where if you qualify, you receive the benefit as opposed to a lottery? What's the chances of Universal Section 8?
Well, you know, I think we know that it was included in some of the president's proposals during the campaign. We're waiting to see sort of how the administration will propose. You know, will come forward with a budget proposal and kind of their full Building Back Better, I think is what we're calling it, agenda going forward. So we haven't quite seen the details yet. I think if it does, I would, you know, it already came up in yesterday's hearing, as you mentioned. Diane Yantel mentioned it, both investments in universal vouchers and investments in the physical stock of housing. We know there's some markets where there's just a real shortage of housing, and so having that mix of options is good, plus the need to provide healthy, safe housing and preserve the affordable housing that we do have, so that we're not rolling backward. We're preserving everything we do have. So yes, as Spencer mentioned, if we had a more robust housing safety net, we wouldn't have had to ramp up the emergency rental assistance program that we've had to do during the COVID period, because, you know, we would have an existing safety net, but we all know that hasn't existed up till now. So I anticipate it being part of the discussions this year. It's just as, you know, the administration, kind of like the Obama administration, when they got here, we're in the midst of dealing with the crisis situation first. And I think now that they will have to implement all those crisis programs at the same time, we're talking about going forward, how we want to deal with the underlying conditions and sort of, you know, build back better. Not to be too corny about it, but to really make progress on underlying issues.
Yeah, I think as the comment that you mentioned that, you know, emergency rental assistance really is in some ways creating the base of thinking about a universal voucher, because you're saying to everybody, well, you know, if you have circumstances beyond your control in which you're not able to pay your rent, and for many people who are working and just do not have sufficient income to cover what is the market rate for housing. So, you know, happy to hear that it's, you know, is brought up at the hearing and it's being talked about. I do not see other questions at this point on the, you know, on the chat. So I know you have some time constraints today, so really appreciate you making the time and giving us this update. It's very helpful to hear about, you know, all the activities that are being considered, and sort of this balance between, yes, we've got a crisis right now, but we also have to think long-term in terms of how we provide and make sure that we have housing stability, that people have, you know, protection in terms of their mortgages, and increasing home ownership, as well as protecting tenants in their housing stability.
Well, thank you. And, you know, I think, you know, please keep in touch with us as these things are being implemented, so we can get that feedback loop going on. We're in pretty constant communication with the agencies that are implementing these things. And so feedback from communities helps us too. And I do just want to do an additional kind of shout out to, as we think about housing, we're also thinking about neighborhoods and communities, both as, you know, direct support for folks to afford their housing, but also to make sure their communities provide good opportunities for them in terms of a healthy environment and access to jobs and transit. We're trying to think holistically about neighborhoods and communities, because that's where the housing is. So look forward to talking with you all about it as we move forward.
Thank you. We'll have you back. Maybe, you know, you give us an update as we move towards that appropriations bill.
Okay. All right. Well, thanks very much, everybody. Thanks for being here.
Thank you. Okay. So as we move on for our updates, we did have some months ago a forum on the source of income protection, and we thought today it would be helpful to hear a little bit more about where, you know, just a little background as to source of income, and then where we are today in our community for source of income. And then we're going to hear a report because other communities have actually adopted it. And so we're going to turn then back to Deborah and Reem. But first, we're going to hear from Michael Lepley, who's the Senior Research Associate at the Fair Housing Center for Rights and Research, to give us a sense of what's happening here in Cuyahoga County around protection for tenants based upon their source of income in terms of paying their rent. Michael?
Thank you, Phil. Quick plug from my agency. The Fair Housing Center for Rights and Research is a full-service fair housing organization serving Cuyahoga and Lorain counties. We provide education on housing rights for everyone in the community, including housing providers. And we work directly with folks experiencing housing discrimination. We do investigations of housing discrimination, and we provide community research on structural issues related to discrimination and residential segregation. I think I have a slide presentation that Catherine's going to put up. There we go. Get set up here. Okay. So I'm here to give an update on source of income advocacy in the Cleveland area. So we're all on the same page. Source of income is a term that generally means the prohibition of landlords refusing to accept housing vouchers specifically, and sometimes other federal and local housing subsidies like rapid rehousing vouchers or other forms of supplemental income. My agency has done a bit of research on this topic over the past 5 years, which we've presented at length in this forum in the past. I'm going to briefly go over some of it to show why this regulation is important, and then I'll talk about our advocacy efforts in the Cleveland area. So if we could go to slide 2, Catherine. I'm not sure if it's skipping. There we go. So in 2016, we released a report called Housing Voucher Mobility in Cuyahoga County. On this slide, you can see a map from that report. This map is showing concentrations of housing choice voucher program households in red, in the red dots. There are about 16,000 households that use vouchers in Cuyahoga County. And they're overlaid the racial and demographic distribution in Cuyahoga County. So using a spatial analysis, we showed that participants of the Housing Choice Voucher Program, who are 90% African American in our region, are concentrated in neighborhoods with high poverty, high exposure to environmental health hazards, and low educational outcomes. And national research later came out confirming our findings, showing that the voucher program contributes to racial segregation in the Cleveland metro region. So we can go to the next slide, Catherine. Thank you. So as part of our research, we surveyed hundreds of participating households with the help of CMHA. That's our largest housing authority in the Cleveland area. And our respondents told us a number of factors were preventing them from finding their preferred housing, but the number one overwhelming factor was landlords refusing to accept their vouchers. And many reported to us that they would move if they were able to find units. They also cited a number of financial issues, many of which we're proud to say that CMHA has addressed over the past 5 years. For example, CMHA has implemented, or they across the board raised their payment standards for 2 and 3 bedroom units. So units that families with children would need. And then they've implemented exception payment areas, which means that units in census tracts or zip codes with low poverty can earn extra money from the housing voucher. So we can skip to the next slide. We also surveyed landlords to understand their perspective. Many of our landlord respondents said to us that the application process was too complicated. They were frustrated by the inspection process. And then some repeated some stereotypes of the program or of participants themselves. Again, here, I'm happy to report that CMHA has addressed a lot of the issues that our landlord respondents raised. For example, CMHA streamlined their inspection process, made it much faster. They hired a landlord and they hired a landlord liaison. And I want to briefly talk about the inspection process, because I think that some of the issues that the landlords raise are based on misconceptions. So the inspection process specifically is called HQS. It's designed at a national level by HUD. HQS stands for Housing Quality Standards. So, you know, one issue that gets raised sometimes is that HQS is burdensome. They're asking for too high of standards, and I think that this is an incorrect assumption about housing voucher inspections. HUD designed HQS to be a bare minimum housing standard for habitability. It was intentionally designed to be less restrictive than most city building codes. So if a unit can't pass HQS, it probably can't pass, probably can't stand up to a city's housing standards. The other landlord concern I want to address that we hear often, both from landlords and from community members at large, are stereotypes of the folks who use the housing voucher program. That they're bad tenants, that they rip up units, that they're bad neighbors. And I think that this is factually not true, that housing choice voucher program participants are categorically bad tenants. Some national level research. Well, first I should say that the program incentivizes tenants or program participants to be good tenants. They lose their housing subsidy if they're not. And national research has shown that folks who are using housing vouchers respond to those incentives. They tend to stay in, once they're leased up, they tend to stay in units much longer than market rate tenants, which for a landlord, this means less turnover and potentially they're a more profitable tenant. So with this research, we recommended that the Housing Authority make certain interventions, many of which they did. And we also recommended that as a region, we explore passing source of income laws to deal with the high levels of discrimination reported by our survey respondents. And this is also the focus of our follow-up research that we released in 2017. So we can go to the next slide, Catherine. In 2017, we released a report called Housing Voucher Discrimination and Race Discrimination in Cuyahoga County. And from our previous research, we wanted to determine the relationship between legal and illegal forms of housing discrimination. So our assumption coming from our previous research was that the Housing Choice Voucher Program contributes to racial segregation in Cuyahoga County, and that landlords' unwillingness to participate in the program is a major factor in the failure of the program. We wanted to ask 2 research questions. The first is, does no Section 8, so a landlord saying no Section 8, serve as a proxy for racially motivated discrimination? And under civil rights theory, this would be called disparate treatment. And the second research question we wanted to ask is, does no Section 8 have a discriminatory effect on the basis of race? So even if a housing provider is not racially motivated, does the effect of them refusing to accept a voucher have a discriminatory effect based on race? So we can skip to the next slide. So we wanted to see if landlords were refusing to accept vouchers as a proxy for race-based discrimination. This is something in the fair housing community has been asking for decades. So we used testing to uncover this. Testing is like the secret shopping of housing. So we send out people who are matched in every way except for the base we're testing. So here it's race. So we sent out a white tester and a black tester. So what we did is we set up a web scraping tool that grabbed every rental ad in Cuyahoga County and then selected ads that had specific terms in them relating to the voucher program. So Section 8 spelled in the different ways listed. We randomized them, and then we did a match paired race test where a white and black tester who do not mention vouchers would go and engage with the landlord and then report back to a test coordinator. And then we do this for landlords who mention the Section 8 program. We call this our experiment group. And then we did the same thing for what we called our control group. These are landlords who did not mention housing vouchers in their rental ads. We can go to the next slide. So these are our results from that round of testing. You can see in our experiment group that landlords who say no Section 8 in their rental ads discriminated against our black tester 26% of the time compared to 21% of the time in our control group. What I want to point out is the orange sliver on these pie charts. This is the unfavorable treatment of our white tester. One of our research assumptions is that reverse racism doesn't exist. It's not a thing that happens in reality. So we think of the unfavorable treatment of our white tester as sort of a margin of error. You might call this the rate of bad customer service. You can see in our experiment group that rate is 10% lower than in our control group. And when you subtract that from the unfavorable treatment of our black tester, it's something like 20% unfavorable treatment of our black tester compared to 5% unfavorable treatment of our black tester in our control group. We believe that this shows evidence that some landlords are racially motivated or at least sensitive to race when they're refusing to accept housing vouchers. We can go to the next slide. So we did a second round of testing. We want to get to this question of whether or not refusing to accept a housing voucher contributes to racial segregation. So this is independent of the motivations of the housing provider. And what we did was we used our web scraper again, which grabbed every ad for rentals being posted in Cuyahoga County. And this time we filtered ads. We randomly selected ads from our pool that were 2 and 3 bedroom units within the affordability of CMHA's payment standards at the time. The units we selected were located outside of areas with concentrations of housing vouchers. So in this map is showing census tracts where housing vouchers make up more than 7.3 of all rental households. that's where, for our research purposes, we're going to call these areas of voucher concentration. We're not going to run our tests there. And then the ads did not state up their policy for housing vouchers because the test would be pointless. We know from the ad how the landlord's going to behave. And then we sent what we call a one-part test. We sent an African-American female tester using a voucher who simply asked the landlord, will you accept my voucher? We can go to the next slide. And in that round of testing, we found that landlords refused to accept a housing voucher 91.2% of the county. I have to go back and check the research, but I think when you isolate it to the city of Cleveland, it's something like 95% of the time. We argue that this is evidence that the effect of landlords refusing to accept vouchers perpetuates racial segregation in Cuyahoga County. And based on the previous round of testing, we believe that some landlords are doing it on purpose. So our recommendations from this round of research were that municipalities in Cuyahoga County ought to pass source of income laws prohibiting landlords from refusing vouchers. So I think that, as these two pieces of research focused on race, but I also want to make an appeal based on the fact that we're in a decades-long affordable housing crisis, that the Housing Choice Voucher Program is the largest source of affordable housing monies in Cuyahoga County. And when we as a community refuse to accept that program, we're using it in an inefficient way. So we can go to the next. I'm sorry, did you say something, Phil?
Yeah, just 1 minute left.
Oh, sorry. Okay, I'm gonna go fast. As of December 2019, these are all the places where source of income has been passed. We're getting to the point where most Americans live in jurisdictions where source of income laws have been passed. We can go to the next slide. These are places in Ohio. At this point, Cleveland is the only large city in Ohio that doesn't have this housing right. And then to give you a super quick update of where we are, you might have seen from coverage in cleveland.com that the city of Cleveland is considering passing source of income. There are a number of city council people who are coming out in strong support. There's an ordinance being drafted. In my opinion, it's a very strong ordinance and will be effective. It will be effective and meaningful if it's passed. And I'll leave it there for the folks at Toledo.
Thank you, Michael. That was great. And as you very correctly pointed out, this is an issue that overwhelmingly affects Black communities. It also overwhelmingly affects women and affects larger families. So all of these groups of people end up facing denials from the limited supply of affordable housing in the state of Ohio. There's a very limited supply of housing, and folks who are most in need are facing this denial from those homes that they want to access. Not because they're not paying their rent, not because they're late on their rent, but only because their rent comes from an entity which is the most likely to pay rent, which is the United States government. They're not going to short a landlord one day and fail to pay a tenant's rent. So we are really excited that Toledo passed source of income ordinance protections. This is something that we have been working on for a couple years, actually. We first started working on it back in 2018 with a council member and a couple other council members who were supportive. They brought it to council committee. It did not receive a lot of support. So they tabled it, and they were able to present it again along with pay to stay at the end of last year in December 2020, and the ordinance passed. I'm going to show you the classes that we included to protect in the ordinance. So we included source of income, and you'll see over here, we also included race, ethnicity, religion, color, national origin, ancestry, sex, familial status, disability, age, military status, immigration status, sexual orientation, and gender identity. And we defined source of income so that we would ensure that housing and rental assistance programs are also covered, because we know of situations where tenants are presenting rental assistance money to their landlord and the landlord is denying it. So it's not only a source of income, which is a voucher, but also there's a multitude of other sources of income, such as payments to veterans, such as, like I said, there are so many different sources of income that are often discriminated against by landlords. And our goal in working with our city council was to protect all of those individuals and give them equal access so that your dollar has the same value regardless of where it came from. We also included in our ordinance just an improvement to the general housing anti-discrimination law that we had in Toledo. So most cities have their own housing anti-discrimination protections. And if you're looking to do something similar in your city, you would probably want to get that and see what changes need to be made to it, whether it can simply be amended or needs to be repealed and passed again. Let's see. So I'm happy to share this ordinance with any group that is interested in working on it. Yeah. So something that was important to our city council is to ensure that landlords are informed and educated about their rights. So when we passed the ordinance in December, it didn't actually become effective right away. We have a 120 days after adoption effective date. And then that allowed us and our local fair housing center to have sessions of education for landlords and for tenants to inform them about this new law and that they're no longer allowed to deny tenants access to housing because of their voucher. I had a client myself who is a single mom. She is a Black American, and she spent several months looking for housing and being told, no, we won't accept your Section 8 voucher. And so she was really excited about the passage of this law. And you'll see here that unlike the pay to stay, that we do have a penalty here, which is more important in this type of an ordinance because a pay to stay will be utilized when there's already ongoing court engagement. So it's going to be within the purview of the court to enforce it, whereas this may not be a court-related action. The landlord could just deny housing and the tenant would then be left alone, unsure of what to do. And so there's a penalty provision for the violation of this ordinance. That's all I have. Phil, if you're speaking, you're muted.
Thank you. Okay, last but not least, we are going to turn to Kate Carden, who's the Assistant Director of Community Resources at CHN Housing Partners. As Beth Cooper mentioned, there's over $45 billion that have been allocated for rental assistance, and some of the original funds from December had limitations, which are now different in the next round of funding. So we asked Beth to give us an update as to what has been done and what the future looks like in terms of providing rental assistance for tenants who are in need.
Yes.
Okay.
Hi, everyone, and thanks, Phil. It's nice to see so many friendly faces today. So I will keep it quick. I will do a quick overview of what we've seen at CHN over the past year, and then what we might anticipate with the new Treasury funding. So going through, if I can get my controls to work here. There we go. So in 2020, CHN Housing Partners partnered with Eden to administer rental assistance programming for both the city of Cleveland and Cuyahoga County, as well as several local suburbs. With this program specifically, I always have to give great thanks to both the city, the county, all of our partners, because this truly was a great partnership across all levels, where you saw the city, the county, organizations, the suburbs really collaborating and coordinating to ensure that this program rolled out in the best way possible. We partnered with CEOGC, now known as Step Forward, and the program was designed to help residents of both the city and Cuyahoga County who are having trouble making their payments due to COVID-19. So the eligibility is pretty simple. Anyone who lives in the county with an income at or below 80% AMI with a COVID-related hardship. And so the way it has worked and will continue to work is CHN is the primary entry point for rental assistance. So folks can complete our application in English or Spanish at neorenthelp.org, or they can call this toll-free number, where we can also accept applications by phone. So if folks have a digital divide, they can give us a call. We will complete those applications for them. We are also screening all applicants for utility assistance programs. So last year, as well as this year, with additional resources, we have the ability to pay utility expenses. And the way that will change a little bit this year is when the utilities are charged from the landlord to the tenant, and it appears on their ledger, we are able to treat that as quote unquote rent, and include that with any payments that we make to that landlord with rental assistance or rental arrears. We are giving priority to tenants who are already in the eviction process. And then per the new FAQs, the emergency rental assistance FAQs, we also are providing priority to those with incomes less than 50% AMI or those who have been unemployed for 90+ days. If I get to some graphs a little later on, you'll see that almost our entire pipeline is at or below 50% AMI across the entire county. So all of the applicants applying to our rental assistance program are low income or very low income. Under the new guidelines, if an applicant qualifies, we can cover up to technically 15 months of rent. We can pay up to 12 months of arrears using the new Treasury assistance, and potentially another 3 months of ongoing payments. And then as people apply, we're also finding that at least 60% of them also need utility assistance. So if you're ever working with a tenant and you notice on the application, we're asking for utility bills, just a lot of information about their utilities. That's why our hope is that this application can kind of serve both purposes. And, we can act as a one-stop shop and get all of that assistance to the tenants. So just quickly, where we've been at over the past year is our program started July 1. On July 1, we had 1,400 applications. We continue to see a great number of applications through the remainder of the year. And by the end of the year, we completely spent down funding that Cuyahoga County had received that were also CRF or Treasury dollars that at that time had a deadline of December 30th. So we were able to act as good stewards of that funding and spend all of it before the year's end. And just that CRF funding totaled $5 million. At the beginning of this year, we started reaching out to other rental assistance operations across the country, some models and best practices. Charlotte Mecklenburg in North Carolina is one. Action Housing in Pittsburgh is another, where they have seen a very large number of tenants coming through their pipeline. And we just wanted to best set up our program to move forward with the Treasury assistance dollars the best way we can. So far, we have spent almost $14 million through block grant dollars provided by the city and the county. And then looking forward, what we have is currently through Cuyahoga County, we have been approved for 10 million of the recent emergency rental assistance dollars. The county went through a formal RFQ process. CHN and several other organizations responded, and we will be working closely with several of those agencies to ensure that we have a footprint across the county to get this assistance out there. In Cuyahoga County, we also have a bit of block grant assistance dollars left. And then in the city of Cleveland, what we are anticipating is Treasury funds, block grant dollars, and some general fund dollars that will total around $20 million. And so we know the need is great, and we know that that assistance probably is not enough to cover the needs. So we are looking forward to any additional funding that might be coming down the pipeline. But again, through the new Treasury assistance, we can provide up to 15 months of rental assistance for folks, up to 12 months for arrears. And what's great about this assistance, as opposed to some of the funding sources we've used in the past, is there's no cap on assistance other than it be used for rent and housing costs incurred after April 1st of 2020. There's no fair market rent value cap, which hurts some of our county residents or downtown residents. And we are allowed to pay for fees. So things like court fees, late fees, we can now include those in our payout to the landlords. And so when someone applies, what we're doing is reviewing to see if they are automatically, or I shouldn't say automatically, but are eligible for future 3 months rent payments. As I had mentioned before, almost our entire pipeline is at 50% AMI or less, meaning they really truly need future assistance to ensure their stability. And so I'll stop there and just let people know if they need to reach out, if they have any questions, please feel free to reach out to me directly, even if it's just to follow up on a tenant application, and we can see what we can do to help.
Thank you very much, Kate. You're doing incredible work, working with lots of people. I guess there have, one question is, some concerns have been raised about the length of time it takes through the whole process to get the money out. Can you talk maybe a little bit about, what are some of the barriers or challenges that you face in making sure that, applications are funded as quickly as possible?
Sure. A lot of it comes down to the documentation. Last year, when the program began, we weren't yet able to use self-certifications for income and hardship. And so right off the bat, we saw documentation was a barrier. We fixed that. The city and the county did then move to accepting self-certifications. That's a little bit different with the new Treasury guidelines. We do need to obtain a little bit more income documentation for files. We are staffing up significantly. And so our goal is for a 24 to 30 day turnaround time. So we are allowing tenants 7 days, in the application queue, and landlords 10 days to send their information back. A large part of the barrier is we are working, it's a tenant-based program, and we are relying on the tenants to provide landlord information. And so sometimes we get an application that says, my landlord is Bob, and that's all we have to go on. And so we're trying to be a little bit more targeted in how we request that information up front, a lease to go on, things like that.
Okay, thank you. We have just a couple of minutes for questions. They're back on source of income. One of the questions that was raised was if somebody was self-employed and would that be something that would be covered by source of income? So I guess first the question would be, in Toledo, how does that work? And then sort of thinking about what's going on in the thinking for the Cleveland ordinance.
So, we would argue that any source of income is protected, that a landlord cannot discriminate no matter what the source of income is, whether it is self-employment, a subsidy, a payment because from their trust, or a rental assistance payment.
And is that an issue that's been looked at for the Cleveland ordinance, Michael?
I'm looking up the definition right now. So that question in particular, to clarify, was self-employment if the employment was illegal drug activity, in which case most civil rights laws aren't going to protect someone in that situation.
I think we've got to be clear that when we talk about self-employment, we're talking about somebody who would actually have some type of documentation, because it's fair for the landlord to say, I need to know that you actually have the income to afford it. But just because they're self-employed, and I think the question was raising whether there's a proxy for illegal activity, but if it's illegal activity, they're going to have difficulty showing, a actual regular job or employment or something that they're doing, where they, where it would look like employment. But.
So the definition, definitions and source of income are important, and I pulled up the draft definition, and the source of income means any lawful income. So I think that, yes, it's going to cover self-employment if that is a legal form of self-employment.
Yeah, our definition also states lawful occupation. So I didn't know that the question was about unlawful employment. So I would push back in general and say that in such a situation, the landlord would have to present some evidence that they believe that this is unlawful employment, rather than just making a blanket and potentially racist allegations.
We had a question on pay to stay about, the whole question about evictions and criminal versus civil. I think just to clarify, all evictions are civil actions, and they're covered by a specific section of the Ohio Revised Code 1923. And so I don't believe that any of the pay to stay efforts have anything to do with, engaging with criminal law. This would all be under Ohio's civil statutes involved with, with evictions. We also had a couple of concerns that were raised about the whole process of the HQS and inspections, and the process that CMHA uses, and whether, how vouchers, are accepted by landlords and things like that. And what seems to me is that that's outside of the purview of today's forum, but we certainly could think about, and I will bring that to the attention of the planning committee, that the possibility of having that as an issue, looking specifically at how the housing voucher program is presently working, how do the inspections work, what are the concerns that landlords, have about those programs. So we are up against the end of our time. I would like to thank all of our presenters. Molly and Deborah and Reem and Michael, Kate, and Avery and Beth for their time today and for their insights and information that they're providing. If anybody has follow-up questions about local efforts around pay to stay, please feel free to contact Molly at NEOC, and she'll be happy to, answer those questions. I know Reem has been very clear that she's happy to share her legislation, and Deborah, there were some specific, legal questions about drafting or the way to apply some ordinances. So, and she did include her, her email in the chat. So I'd like to thank all of the panelists, but I'd also like to thank everybody who attended today, taking time out from your celebration of St. Patrick's Day. So it looks like it's a very nice day in Cleveland. So thank you all for joining today, and I'll turn it over to Chip if he has any other final comments.
Just one thought. There's a major project over in the Buckeye Woodland neighborhood called the Wood Hill Project, and it's $45 million. And a lot of the people who presently live in the projects would be vouchered out. It would really be terrific if this ordinance passed locally, maybe the county or the city, give people real housing choice as opposed to this limited ability that we've seen over the years, which just exacerbates housing segregation in Greater Cleveland. Thanks to Phil. Thanks to everybody on the planning committee. Everybody have a happy St. Patrick's Day. And maybe we're all going to get eventually out of the COVID thing. And I think we ought to have Sherrod Brown on one of these things to talk about what he's going to do about housing and banking. Thanks so much. Have a great day, everybody. Bye-bye.